You're tuned into the podcast where justice meets Southern hospitality. Broadcasting directly from Savannah, Georgia, join your hosts, Paul, Stephen, and Andrew of Bowen Painter Trial Lawyers as they chat about the legal difficulties you might face in everyday life. From the ports of Savannah to the busy highways that stretch through the Southeast, we're your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
All right, welcome back to another episode and another season of Justice for Y'all. I'm Paul Painter, and with me as always, Andrew Bowen, and from the great state of Minnesota, Stephen Morrison.
The Great North Woods.
Stephen, why don't you tell everybody why you're not sitting in the room with us?
He's even dressed like a lumberjack, in case you didn't catch that.
Yeah. What is the temperature here? I think we were in the 40s this morning. We warmed up to a crisp 60 degrees, sunshine. So my wife was born and raised in Minnesota, and both of us practiced here several years ago. Aaron went to law school here. We moved to Georgia when I was going down to the U.S. Attorney's Office. Then, of course, I joined Bowen Painter. And then we decided that we missed 4 seasons or were crazy. We had a kid, a lot of things changed, and we find ourselves making our way back up to Minnesota, where I'm licensed to practice, and still doing Georgia stuff. But we're nationwide.
We are.
Top to bottom, east to west.
I don't know what you mean about not having seasons down here. We just had a false fall,
Yeah, that's true. and not to mention,
the problem was there were too many seasons in Savannah.
Right.
And not to mention, I think Minnesota basically has winter and a month-long spring, doesn't it?
Yeah, that's about right. But if you like winter, which I surprisingly do, more than a lot of Minnesotans even, it's a good place. It's a bad place if you don't like winter.
Yes. Well, we were up there for our partner's retreat, a couple weeks ago, and got a great cabin on Lake Superior, and learned that Superior has 2 states. You have frozen ice and frozen water, or frozen liquid. Yeah, right. It's all liquid. Water. And that's why I'm not in
solid
science.
Ice and liquid ice.
Solid ice and liquid ice. There you go.
Can we edit that, please?
You nailed the delivery on that one.
It's like I said it. I'm like, I don't think that's right.
You leave the jokes to me.
Yeah. That's that's where we are, ladies and gentlemen. We're leaving the jokes to Andrew.
I think one of the saddest things is that when we do this, I'm only looking at Paul. I don't get to see Andrew. So.
See, I would have thought that's a plus.
I know. I missed that mug.
Well, we're probably going to have this in a different room before too long. Maybe in a different office. We're talking about moving offices, so we may be in a different office soon. And if so, we'll set up something to where you can see everybody.
I like that. That's exciting development. I hope that that's all TBA at this point, I think, but looks like it could work out.
Yeah,
that's right.
We're on the track. So, guys, we've had quite a few developments in the firm since we last recorded a podcast. Y'all want to talk about some of those?
We were talking about Stephen moving. What else did we do?
Well, we are officially docketed for oral argument in the United States Supreme Court.
Yes, we are. That is the Hensley versus Fluor case. Andrew, tell us about that case.
Well, our client was a soldier in 2016 on Bagram Air Force Base in Afghanistan, and was out with some friends. They were going to do some training for something on base, some physical
combatants,
physical combatant training, and they encountered a local Afghani person wandering around the base and recognized that he was out of place, wasn't supposed to be where he was. And when they confronted him, he blew up his suicide bomb, his vest that he was wearing, severely injuring our client. It turns out that this bomber was an employee of a defense contractor, Fluor Corporation, whose job on base was essentially working at the on-base Jiffy Lube. His job was to empty and dispose of the fluids, oil, antifreeze, whatever fluid needed to be disposed of when these vehicles were undergoing maintenance on the base, and that was one of Fluor's duties on base, is to perform that vehicle maintenance. So they hired this local nation employee from Afghanistan, which was fine. In fact, the Army encouraged defense contractors to do that, to try to help them become trained for a thriving, hopefully a thriving economy. But as it turns out, this guy built his bomb at his work site using Fluor's materials and tools.
Tools that he should not have had access to, too.
Correct. So, his job was essentially to carry buckets of fluid and empty them into a larger drum. Yet he was so unsupervised that he managed to build his device under their nose. And not only that, on the day of the bombing, he left his work site. So within the confines of the base, these work sites are also discrete walled-in areas with a gate. And the defense contractor is supposed to keep the employees inside the gate, and when it's time to leave after their shift is over, have eyes on escort on a bus that carries them to the gate of the base, and eyes on to see them through the gate, so that they're never left free to roam about the base. And when they come on the base, it's the same thing in reverse. Well, Fluor didn't do that either. They didn't get this guy on the bus. They didn't keep him confined to his area, which allowed him to take the device that he had built under their nose and blow up our client and multiple other soldiers, some of whom were killed. So we filed this case in the District of South Carolina several years ago. The court granted a motion to dismiss based on a little known and technical legal ground, which we can get to in more detail in a minute. We appealed that decision to the Fourth Circuit Court of Appeals up in Richmond, Virginia. And after a multi-year wait for an opinion from the Fourth Circuit, they finally upheld the lower court's ruling and said, no, this case should have been dismissed and we're going to uphold the ruling. We then petitioned for certiorari, which is review by the Supreme Court, United States Supreme Court, and ultimately we were granted certiorari, which was a huge deal for us and for our clients and for this area of law. And so we're docketed for oral argument in Washington, D.C. on November 3rd of this year. So we're all looking forward to that milestone.
Yeah, it's going to be a neat event because, for most firms in America, it is a very rare event to go to the United States Supreme Court. And, I don't think just in Savannah, I can't think of, I think there's been one or two other firms that I know of that have done it. I mean, in 30, 40 years, like
right.
People who are actively practicing.
Yeah.
So it's extremely rare, and it's really going to be a neat experience and all the pomp and circumstance of the court, the highest court in the land. So right. It's pretty cool. And
most importantly, we hope to get this case back and hold this defense contractor accountable. Do y'all want to discuss the legal aspects of this issue, or do you want to save that for another podcast?
I'd say save it for another podcast. When we get done with the argument, I think we need to have a whole segment on the experience, and we can get back into it.
So stay tuned for that. Hopefully we'll have good news on the Hensley case against Fluor Corporation. Some other big news, though. We've had a couple of trials since we last did a podcast.
We have. I think our last podcast was right after the first trial, the Collier trial.
After the Collier trial, that's right. So we discussed that.
We got to break that one down.
But Paul and Stephen, after the Collier trial, traveled out to California, Los Angeles, California, in the middle of riots and ICE deportations, and tried a case out there. So let's take the top line, guys. What was the result of that trial, and then we'll talk about it in more detail.
$21.3 million.
That's a great result.
Yeah, we were very pleased with it.
It was
very deserving clients too. They fought a long time through a lot of adversarial situations to get to the end. So, and it was and basically that case is the reason why we let's just say took a break between season 1 and season 2, because the trial, we were out there for a solid month. Steve and I both went home for about 36 hours over 4th of July. Other than that, we were there for 30 days. And with the trial that long, the month before, we were pretty much doing nothing but preparing for it, really a month and a half.
Yeah.
And so that was about where we left off. And so things like podcast, I'm afraid, had to go by the wayside. But it was an experience. Now, before we get into it, we can tell a little bit about the case, but we're in the judgment is being entered. Part of it's already been entered, and the defense has filed a motion for a new trial. So we're in post judgment territory with these motions, and we expect the defense to appeal. So we can't really get into a lot of the details of the trial you might want to hear because we don't want to jeopardize our clients' appeal by boasting about all our great legal work that could be used against us.
Well, let's talk about first of all how we ended
know there
up.
are a lot of defense lawyers who listen to this podcast.
That's right. Yeah,
they all do.
Yeah.
Let's talk about first of all how did Bowen Painter from Savannah, Georgia, wind up in a case trying a case in Los Angeles, California?
It's a great question.
This is the number one question. Not what were the facts of the case, not what who got hurt, not what company. I mean, that is the first question. What the heck are y'all doing in California?
Yeah, well, I just say, we're a nationally sought after firm, of course.
Taking names
case,
is what you're
give
doing.
us a call.
The obvious answer.
So it kind of goes back to COVID, and we've talked about this a little bit. Our business model has been we have a fairly small number of cases, and they're often larger cases, and you got to get these cases, close to trial to be able to resolve them for what is good for the client. Well, in COVID, when in Savannah especially, the courthouse completely shut down for trials for a year, and then the backup of trials that came from that delay really made it difficult for us to do the job that we wanted to do. And so we started looking around to say, well, where can we take our skill set elsewhere? And we had a friend who was practicing in California and said, well, why don't y'all come out and try a case with us? Just me and Andrew at the time. And so I got involved with the case, and we had a lot of value to it. And then Andrew and I both went out there and tried a couple of cases each. And another lawyer in Georgia, we had the family that we represent in this case we just tried is from North Georgia, where my family was from. And they had lawyers out in California. They weren't happy with them, and they wanted to find another lawyer. And they found out through kind of a chain of events that we had been trying cases out there and contacted us. And so I drove up there and sat down at McDonald's and met with them. And they ended up deciding to hire us. We looked at the case and said, well, I think it's something we can do something with. So we did that and found some great local counsel out there. Tim Loringer with the Wisner Baum firm, their national practice, and started litigating the case. So it sort of had a long and winding way to get to us, to where some, Georgia lawyers and Georgia clients go out to L.A. and try our hand, but it worked out.
And this case had been around quite a while.
Oh yeah. That's why they were looking for. They wanted to get the case tried. It had been, the wreck happened in
2017.
2017, yeah. Like that. Funny, I knew these facts pretty well about 2 months ago.
That's how your brain works.
Yeah, I got to
That's
dump
called
it for
neuroscience, which we also learned a lot about.
We'll get that in a second. But yeah, so it was a tractor trailer on van wreck in 2017 on I-40 in New Mexico. Actually, the trucking company and the driver from LA, which is how it wound up there. And it had been in the court system for 5 years, and so we came in and had to get it ready for trial. It had been, all the witnesses who were going to be part of it were already part of it, but we had to take it from that phase to actually get it ready to try, and that's what we wound up doing.
Well, I know we can't talk in detail about a lot of the trial, but just tell us, if you can, what were the basic facts of the case?
Yeah.
Who were the plaintiffs, and what sort of injuries did they have?
It was this family from North Georgia, the Morgan family, and it was the mom and dad, and then there were 4 kids in the car, and one of them was an adult daughter. And they had been coming back from a vacation in Colorado, and they were driving back, and it was just turned dark, and the tractor trailer came up and just hit them from behind and damaging the van. The driver said he dropped his water bottle. We thought that he was probably asleep at the wheel based on the terrain and everything, and got into that in the trial. But anyway, the seats on the van broke, and due to the mechanism of what happened to the people in the van, everybody but Dad, who was driving, ended up getting hurt to various degrees. And the two folks that we took to trial were the two daughters who were in the middle row, Sarah and Asia, and they both suffered brain injuries from this, from a combination of the movement of, and Stephen get into this, he became a brain injury expert during the course of this preparation and trial. He handled all the neurologists and neurosurgeons and everything else. So you can tell us about that in a second. But and so they both had these brain injuries, which was terribly sad. And then the Asia, the older girl, had this fairly rare condition from a pinched nerve called persistent genital arousal disorder, which is a terrible, terrible ailment that makes one feel, it's like sciatica, except for the genitals. It just is a constant feeling of pain, and we won't get into the details on this podcast, but it's really a sad situation. And so that's what they had, and they've been dealing with for all these years. Stephen, you want to talk about the brain stuff a little bit?
Yeah. So this,
I'm not going to say the
like
terms.
a lot of our, I was trying to beat you into it. It's a joke from Closing Argument.
Yeah, I mispronounced every brain term that I could. It just couldn't come out right. Like strategic. With the emphasis on the wrong syllable.
You had some good W moments. It was kind of throwback to early 2000s American politics. And I'm sure that's what the jury was thinking too after, several weeks of brain science. I mean, there was a liability question, and we went through that and spent some time. But the big issue, really, you got a rear end tractor trailer collision. Should be pretty clear what happened. But the damages were significant and persistent, and it wasn't like these two young women ended up as vegetables, so to speak. I mean, they still were able to be out and about, but their lives have changed dramatically. Their cognitive function was severely impaired in different ways. And then for the younger of the two plaintiffs, for Sarah, she had some really debilitating vision and balance issues that have basically left her, in a position where she can't get around on her own. She relies on her family members. So, a lot of the classic specialties were involved here, and some. It's not cutting edge, but it's not science that you run into if you just go to the emergency room and get your head looked at. If you bang your head, you go to the emergency room. You're not getting a lot of the workup that these girls ended up needing because of the nature and extent of the brain injury. The kind of the classic thing is that a traumatic brain injury from an accident usually resolves after a period of time, but there are instances where it doesn't, and these girls fell into that category of folks who continued to suffer. So we had so many experts in the case, largely dealing with these issues, and a neurosurgeon, dueling neuropsychologist. So the neurosurgeon is both qualified to go in and intervene with neurological issues in the brain and spine, but also to read imaging. The imaging that was really key to a lot of this was, or at least to some of the stuff, was brain imaging through MRI, diffusion tensor imaging, DTI, and all that goes into that, what the significance of it is, and how it correlates with all the clinical symptoms, which were observed by both, the neurosurgeon, but also different specialties other than the neurosurgeon. We've got the neuropsychologist who can use these specialized tests to measure cognitive function and tell you degrees of impairment. A lot of folks are familiar with that from kind of IQ analysis endpoints. So you can get a sense of where pre-morbid condition was, they call it, basically before you got hurt. You were at such and such an IQ level, but then after the traumatic event, you lost these IQ points. Doesn't mean you got dumber, but it means that your cognitive function, whether because your vision is thrown off and you can't see things, or your perception is messed up, or your balance is off, it does have an effect on your IQ. And we can show that kind of before and after picture. And then you get the eye specialists. You've got folks that specialize in the optometry, how the eye works, the ophthalmology, the brain and the eye connection. And then also the vestibular folks, the ENT. I can't remember what their actual practice. I think it's otolaryngologist, which I don't know how you get ENT from that.
It's one of the ones I didn't
ear,
pronounce.
nose, and throat.
Yeah, yeah, but they're also head and neck, and they have
Right.
they're one of those mini title. They're head and neck, or surgeons as well. I guess they've just never decided what title they like, so they just took all of them. And then they come in and talk about the brain functions with respect to balance and how there's an inner ear component and then there's a brain component to that. You got to deal with what's going on here, what's the cause, and so we've kind of marched through all these specialties over the course of about 2 weeks of testimony on just this stuff. I think if you added it all together, and we've had cases dealing with this and dealt with these providers, but it was certainly the first time I had ever had all this in one place in one trial at one time, and it was fascinating. And the most rewarding part about it is that the jury was very engaged in it,
Right.
attention,
Because it's very
and
dense information, and there's a lot of
so
it.
dense.
Yeah.
Well, you're getting it from both sides, and it's a lot.
So,
And that goes to one of the things that made this trial so difficult is we had a total of 23 experts on both sides, something like
That's
that.
about right. Yeah.
Yeah.
Give or take one or two.
I mean, that is a lot of expert witnesses in a case. It is typically, maybe you have 3 or 4 experts per side on a very complicated case, in a medical malpractice case where it's all expert witnesses. You'll have, there's many cases we have no experts or maybe 1 or 2, but to have 23. And the difficult part about that, especially, is you hear Stephen talking about all the specialties in different areas. We have to be prepared to cross-examine these doctors in their areas of specialty. And sometimes we're doing 3, 4 of these in a same day. And so the preparation for that and being able to do it and do it effectively, so we're making points both to make sure our witnesses get out what they should be saying and not ramble on, as we had some problems with, or get the other side to have them poke holes in their opinions or even flip them is really challenging work. So it was a lot of work to prepare for this case, and it was exhausting.
on a little bit lighter note, when y'all, I don't know if you remember the date, but when you and Stephen flew out to California and you rolled up to the DoubleTree in downtown Los Angeles, there was a little bit of something going on outside, wasn't there?
So that's when the LA riots were happening over the ICE deportation. And the riots were not all over Los Angeles. They were confined to about 4 square blocks. And those 4 blocks were the exact blocks between our hotel and the courthouse. So we joked that we learned how to light a Waymoo on fire when we were out there.
Right.
But never actually got to do it.
No, we didn't walk outside. We got so acclimated to being in downtown LA that we walked outside one time and there was like something afire in the middle of the road, and we were just like, all right, let's go in the store. Didn't think anything of it here.
We didn't realize that gas masks needed to be part of our trial kit until this trial.
Yeah.
Well, fortunately,
they were still on back order.
Fortunately, the riots were really just ending as we were starting, so we didn't have to, cross a picket line or anything to get to where we were going. But
no, but there was definitely. There was obviously, I don't know how much of that plywood is just there because it's downtown LA or they put it up special for the riots. But you get the concrete barriers. Remember, the National Guard was still hanging around all the federal buildings because you had a couple of federal buildings. We were in an old federal courthouse. And I definitely could see it was on the down slope. We did have that one day though. It was a weekend. We took a break.
Yeah, the
went
protest
down to the Chinese theater. Yeah, but there was as we were just another day in LA walking out of our hotel, and there's just this caravan of vehicles honking horns, people hanging out waving, mostly Central and South American flags. It was an interesting time. We were right in Little Tokyo too, so we had a whole other cultural element on the backside of which was a lot of fun.
That was great food.
Yeah, really great food. Good shops, good coffee shops we found and made our own.
Yeah, and that kind of gets to, you know, even a lot of lawyers are not used to being gone for very long to try a case. Usually they're, in Georgia, where it's usually a week or less. If it's a big trial, it may be 2 weeks. It's not a month. And you're somewhere close to home. Maybe you're not in your hometown, but you're not too far away. So, the question is, what is that? How do you do that? And the answer is this hotel, because of its proximity to the courthouse, rents out to lawyers they call war rooms, and it's basically a conference room. It had a couple of conference rooms. It had the kids conference room. It looked like, and then we had a copier room, and then a big conference table and some workspaces that they'd rent out to us, and that's where we worked. It's in the middle of the hotel. We get back for lunch, or after the trial's over, we go in there and have our computers set up and everything. And we bought some monitors while we were out there, so we'd have we had our laptops we'd set up there. And then we had a printer that do you ever get that printer working, Stephen?
I'm looking at it. It's working.
All right. Just didn't like LA.
It did not like LA. So it's been it's been rocking right along.
Yeah.
It was an issue with Wi-Fi. I think it's still kind of circa 2000s technology, and trying to get it to connect to anything with one of those little landing pages. It was too much for Wally over here to figure out.
Well, it was an interesting thing because we were up early. We go down and start working, and then every morning the clients, the two girls were not with us every day of trial due to their ailments. It would have been too difficult for them to sit in the courtroom every day, and so the trial was televised. It was broadcast on CVN, which is Courtview Network, which they broadcast kind of larger or interesting trials from around the country. So I'll get back to that in a second. But every morning we would have all the clients come down, the two girls and their mother and father, and we'd have a kind of a brief about what was going to happen that day, and then we'd have a song of the day. And so we'd start off every day right before we went to the courthouse with a song that was picked out based on whatever happened the day before, or kind of what was going on in trial, and sort of had to both to lighten the mood and to kind of keep things focused and get everybody energetic as the day went into it, which I enjoyed. That was fun.
I look forward to that. We had a couple of really good just on point selections, but I think we started and finished with Tom Petty.
Yes, we did.
Is that right?
We started off for them. We won't back down. It won't back down, which was
that's right.
One after however many years, 8 years, and then we ended up as we were waiting for the jury with "The Waiting Is the Hardest Part."
Indeed, it is.
That's right. Yeah.
And y'all actually had quite a wait for this jury to come back. How long did they deliberate? 2
full days. They got the case on Thursday afternoon, and they didn't have much time to start deliberating. They wanted to go on home, and then all day Friday, and then they came back on Monday. We'd been there a long time, and so Stephen, he went on home, and I was like, "You go on home, and I'll stay here." So, we just had for the first time in 2 months, nothing to do. There was no work to be done, and it was a weird feeling. I was used to be stationed in San Diego. I was in the Navy, and I saw a buddy down there, so I went down and rented a car and went and visited him. But it was a very long deliberation. They asked 8 questions. Juries can ask questions, but it's usually none. Sometimes it's 1. Most I think I've ever had is 2, maybe 3, but they just kept on asking questions. It was like, y'all just got to make a decision.
They kept wanting read back. They kept wanting read back of the testimony, so we'd have to go back and find it and designate it, and then argue about whether it was within what the jury was asking for. And so we had to ask. I mean, it really was a
right. And so that means they took they'd ask, well, we want to hear Dr. So and so talk about this, and so we'd have to go through, but the lawyers through the trial transcript from this 3-week trial. And find
which is a rough transcript too, so it's not even fully polished up.
Right, and some of the topics they wanted to hear about could have been multiple hours of testimony.
They could have been. We would usually try to keep it as short as possible, especially by the second day deliberation. Nobody, including the judge, I don't think really wanted to keep dragging it out any more than we had to. But we gave them, everybody agreed on what needed to go back there that was appropriate.
Yeah. Well, it's 21.3 million. Is that right?
That's right.
All right. And so the defendants are, they're pulling out all the stops to try to avoid paying this judgment. They filed a motion for a new trial, correct?
That's right.
And,
Yep.
and they have announced their intent to appeal should that not be granted, correct?
That's correct.
All right. Well,
Yep.
hopefully we can give an update here sometime sooner rather than later and give everybody good news. But sometimes it takes a while.
Sometimes it takes a while.
Wait.
So
Waiting is the hardest part.
that's right. So I'm sure we have a lot of other news from the last several months, but those are, I guess, the highlights. Anything else that we want to bring up just to update our devoted fan?
Well, did you know, I'm sure you do know, that a platypus, the animal, the platypus, both lays eggs and produces milk. And because of that, it's the only animal that can produce its own custard.
Remarkable. That's why it's a miracle.
Yeah.
Is that your joke?
It's just a fun fact.
Yeah. I'm like, is it over?
I know.
Yeah. No, I thought it was, if you think about it, it's absolutely correct.
Platypus custard.
Yeah.
Yeah.
I do not want it.
But that's a delicacy in Australia.
All right, Andrew.
Yeah.
Sorry, you got something else, David?
I got nothing after that.
Well, one small announcement. I tried to create a dating app for chickens. I was going to call it Chicken Tender, but it failed because I couldn't make the hens meet. Most of them balked at the idea.
I think you just laid
Definitely
back.
over.
Well, on that note, I think that's all that you dear listeners can take. So until next time, we're Bowen Painter, and this is Justice for Y'all. We'll talk to you next time around.
Thanks for listening to Justice for Y'all, hosted by the attorneys here at Bowen Painter Trial Lawyers in Savannah, Georgia. If today's episode resonated with you, or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that at Bowen Painter Trial Lawyers, we're committed to justice for y'all.